Good evening. Welcome to the first of the current legal problems lectures for 2023-24. My name is Mark D'Souza. I am one of the editors of the current legal problems lecture series and the journal. And although it's my personal pleasure to welcome today's speaker, Professor Neha Jain, who was my classmate in undergraduate law school way back when, my role for today is very limited. It's my job to tell you that Professor Jain's lecture today will last for about 35 to 40 minutes maybe, and will be followed by about 10 to 15 minutes of Q&A. Thereafter, there's a drinks reception outside, just outside this lecture theatre, and you're all warmly invited to that. So if you had a question and you weren't able to put it to Neha or to Professor Jain during the lecture, maybe you can bend her ear just outside. Apart from that, it's also my job, and my great pleasure, in fact, to introduce you to the chair of today's lecture, Professor Philippe Sands, QC. Professor Sands is Professor of the Public Understanding of Law at University College London, and the Samuel and Judith Pisa Visiting Professor of Law at Harvard Law School. He's a practicing barrister at 11 King's Bench Walk, and he frequently appears as counsel before the ICJ and other international courts and tribunals. He sits as an arbitrator in international investment disputes and also in the Court of Arbitration for Sport. He's the author of numerous academic books in international law, and as well as books for a broader audience. His most recent books include The Last Colony, A Tale of Exile, Justice, and British Colonial Legacy, that's 2022, I think, and East-West Street on the Origins of Crimes Against Humanity and Genocide, which in 2016 was awarded the Baillie Gifford Prize. Philippe served as the president of the English Pen from 2018 until April of this month, and he is a member of the board of the Hay Festival of Arts and Literature. Thanks very much for graciously chairing today's session, and Philippe, I'll let you introduce the speaker for today.
Thank you very much, Mark, for your overly generous introduction. I would have left it to a single line, and I didn't know the entire bio was going to be read out, so my apologies to you for that. Incredibly nice to be here, Mark, as part of the current legal problems series. It's a series that has a long and prestigious and actually wonderful history, and it's wonderful that today we're going to hear Professor Neha Jain, who's going to address a subject. I don't know the full details of the paper, but it does have a certain timeliness about the way in which we deal with atrocity and perpetrators and the role of law and the way in which these things pan out and play out. Professor Jain has a very distinguished history. I mean, I could read out her entire bio and we'd be here for the next 35 minutes, and then we'd have to go straight to questions. So I don't think I'm going to do that. She currently teaches law at Northwestern University, but is very closely associated also with the European University Institute and remains involved at the European University Institute as one of the co-directors of the Academy of European Law, and also a part-time professor, and also a distinguished long history with the Max Planck Institute, and has written extensively on matters of international criminal law and international law more generally. I'm going to stop there, Neha, and hand it over to you, because I think we all want to hear what you have to say. So welcome, you're extraordinarily welcome at UCL. I think we're all thrilled that you're here and rather excited to hear what you might have to say.
So thank you, everyone. What a joy and a delight to be here today with all of you. It's not very often that one is so easily outclassed and minds so little as I am by my chair today. So thank you, Philippe, for doing this as well. And I'm very excited to share this project with you, which is actually quite a new project for me, hot off the computer. So I'm very much looking forward to thinking through it with you. I don't often begin a talk with Leonard Cohen, but amongst the unlikely themes he wrote on was actually the character of Adolf Eichmann. In All That There Is to Know About Adolf Eichmann, a poem that Cohen published in his little-known collection called Flowers for Hitler, Cohen wrote, "Eyes medium, hair medium, weight medium, Height, medium. Distinguished features? None. What did you expect? Talons? Oversized incisors? Green saliva? Madness? I don't know if Cohen had actually witnessed the Eichmann trial from afar, or if he came to it as a vicarious observer through the reportage of Hannah Arendt, who described Eichmann as a ghost who had caught a cold, or that of the famous Dutch novelist of ideas, Henry Mulisch, who saw Eichmann not as an antichrist or the Genghis Khan, but exactly the opposite of greatness. Eichmann is the smallest human being. Neither do I know to whom Cohen is posing these questions. Is it the participants in the trial process, the trial of Adolf Eichmann? Or to humanity, staring at Eichmann in the bulletproof glass dock? Trying in vain, as Martha Gellhorn wrote, to answer, how is it possible? He looks like a human being, which is to say he's formed as other men. How can he have been what he was, done what he did? How is it possible? And in this talk, I want to argue that the practices and scripts of mass atrocity trials continue to grapple with these questions. But their response to it is to shy away from acknowledging and responding to the diversity of perpetrator experiences in mass atrocity. Instead, international trials construct flat perpetrator narratives. And these narratives are intimately tied to international criminal law's attempt to justify itself as a normative project that claims to act in the name of humanity. And finally, I'll argue these stories of extraordinary perpetrators hurt rather than help the normative project of international criminal justice, and that this project would be better served by a different set of trial narratives that engage with the common humanity of those who commit mass atrocity. So to begin, how does international criminal law see, think about, and represent perpetrators of mass atrocity? Holocaust historian Raul Hilberg is reportedly said to have asked, wouldn't you be happier if I'd been able to show you that all the perpetrators were simply crazy? And I want to suggest that international criminal trials have been driven not so much by an impulse to label the perpetrators of mass atrocity as crazy. If they did that, it would be the grounds for an insanity defense, and it would be much harder to try these people. But instead, international criminal trials have tried to construct representative perpetrators who failed at the project of being human in one way or another. And I want to explore with you three types of unidimensional perpetrator portraits that are put forward by different stakeholders in international criminal law, both inside as well as outside the courtroom. The first of these is the depiction of perpetrators as representing some sort of radical evil that puts them beyond the pale of humanity. And there's been some incredible recent work on prosecutorial opening statements, for example, which shows recurrent patterns and strategies that simultaneously depict perpetrators as ruthless, power-hungry manipulators, or as possessed of savage and human qualities. A particularly vivid example is the opening statement of prosecutor David Crane in the CDF trial before the Special Court for Sierra Leone. And I'm sorry I can't quite channel his voice, but I will try. He opens with these words: "A people have stood shoulder to shoulder, staring down the beast of impunity. The jackals of death, destruction, and inhumanity are caged behind bars of hope and reconciliation. The light of this new day, today and many tomorrows ahead, are a beginning of the end to the life of that beast of impunity, which howls in frustration and shrinks from the bright and shining specter of the law. The jackals whimper in their cages, certain of their impending demise." This might be slightly hyperbolic, but it's also not a complete anomaly. Accused across different international courts and at different levels of seniority have been described as evil spawn, hounds from hell. The media, too, has often used dehumanizing language, especially when it comes to high-profile accused, describing them with exaggerated monikers such as Colonel of the Apocalypse or the Butcher of Bosnia. The vanishingly small number of female perpetrators who've actually been tried by international criminal courts have been particularly susceptible to being cast as monsters in gendered ways, with scholars arguing that they're labeled as monsters, mothers, or whores, both inside and outside the courtroom. The Rwandan Minister for Women's Development, for example, was claimed in media reports to violate our very sense of what women are. Whereas in the opening statement, the prosecution described her as a woman who had lost every sense of feeling. Biljana Plavšić, the former co-president of the Republika Srpska, was dubbed the female Mengele and Miss Necrophilia. Plavšić was also compared unfavorably to her male counterparts, and so perfidious that she could make Karadzic look like an honest man. Milosevic reportedly denied her entry into Serbia, stating that such people, if they're not put in a hospital, must be kept from occupying any public function. One could, of course, argue that these descriptions are mere metaphors, literary figures, with no instrumental purpose as such. But to paraphrase Judge Cardozo, having started as devices to liberate thought, metaphors in international criminal trials have ended up often enslaving it. Heightened emotional appeals to metaphor have even made their way into judicial statements, with judges equating the monstrousness of the accused with the monstrousness of the crime with the sinfulness of the accused. And international criminal justice might be a secular liberal institution, but these extreme depictions of perpetrators, both inside and outside the courtroom, are reminiscent of more of an ecclesiastical law of penance, focusing attention not so much on the crime, but on the offender's sinfulness. The second set of perpetrator portraits stems from the proclivity of mass atrocity trials to view the triptych of perpetrators, victims, and bystanders as both fixed and narrowly demarcated. International criminal trials construct very narrow spatio-temporal borders for the purposes of ascription of responsibility. And this can at times produce perpetual perpetrators, with the moment of the defendant's participation in atrocity moving both backwards and forwards to demarcate the juridical bookends of his or her life. The way in which these temporal points are wielded to yield perpetrator snapshots can take on a particularly poignant quality when it comes to perpetrators who were actually conscripted into atrocity. And let me just give two examples here of accused, one from the International Criminal Court and the other from the Special Court for Sierra Leone. The first is the case of Isa Hassan Sase, about whom there's also an excellent documentary. A former battle group commander and the interim leader of the Revolutionary United Front, the RUF, in Sierra Leone. Sase was convicted on 16 counts of war crimes and crimes against humanity, and he was sentenced to a total of 52 years, which is one of the harshest sentences that's ever been laid down by an international criminal tribunal. Sase's defense had not been that he did not do anything wrong. Rather, what his defense team argued was for a reduced sentence on two grounds. It tried to expand the temporal boundaries of the conduct that the tribunal should take into account. So it pointed to Sase's previous abduction into the RUF. And then it tried to expand the temporal boundaries on the other end, which is Sase's participation in the Sierra Leone peace process. On this account, his forcible conscription at the age of 19 and his loss of life opportunities and choices made him yet another victim of Fode Sanko, the founder of the RUF. Sase also testified that he was forced to train for war with the RUF out of the need for bare survival. The trial chamber did not contest the defense's factual account, but it dismissed it as lacking any mitigatory force in relation to his crimes, since, according to the chamber, Sase could well have chosen another path. The chamber also dismissed the defense's arguments, emphasizing his commitment to the Sierra Leone peace process and to the disarmament. Again, the judges grudgingly conceded his role in bringing an end to the civil war, but they immediately set it against his failure to prevent attacks on UN peacekeepers. And they labeled that as a direct affront to the international community's own attempts to facilitate peace in Sierra Leone. The only dissenting note was struck by Judge Itoy, who chastised the majority for conspicuously failing to indicate whether Sase's proven contributions to the peace process should result in a reduced sentence. An even more challenging case is that of Dominic Ongwen, child soldier turned rebel commander in the Lord's Resistance Army in Uganda. Ongwen had been abducted at the age of 10. There's some dispute about his exact age, but most people seem to converge around 10. And he'd undergone brutal indoctrination as a child soldier in the LRA. Accounts of his capture say that Ongwen was so young and so weak, he was one of the weakest children who was abducted, that he actually had to be carried by the rebels to the actual rebel camp. In one notorious incident that was recounted by an expert witness during the trial, when Ongwen tried to escape shortly after his abduction, he was forced to skin alive one of the other abductees, remove his gut, and put it up on the trees as a warning to other people who tried to escape. The prosecution again made no attempt to deny this fact, but instead it drew a bright line between Ongwen's previous victimization and his actions as an LRA commander, arguing that having suffered victimization in the past is not an excuse for victimizing others. In contrast, the defense alleged that Ongwen's captivity and circumstances had left him with the devil's choice between compliance or certain death. According to the defense, the question of Ongwen's responsibility had to start from the day of his abduction and whether he owned his mind from that day onwards, so as to be able to form the requisite intent for criminal responsibility. The defense portrayed Ongwen not as a free agent, but as much a victim of a war that was not of his making, and whose will remained in a frozen, childlike state from the time of his abduction to the time of his surrender. Once again, the defense's arguments were dismissed by the ICC pretrial chamber as well as the trial chamber, who agreed with the prosecution that Ongwen's abduction and previous victimization as a child soldier had no bearing on his criminal responsibility, even if they could be taken into account in mitigation at the sentencing stage. The picture of Ongwen that emerges from the texts of the judgments was thus not one of painful continuities, but one of definitive ruptures, of a man without childhood who was transformed at the stroke of his 18th birthday from an indoctrinated victim lacking agency to a sadistic perpetrator who commanded a ruthless army. For scholars such as Mark Trumbull, the judge's evaluation of Ongwen's responsibility, as if he had never been a child, let alone a child in the LRA, is illustrative of how narratives of agency, choice, and constraint can become instrumentalized by judges to suit the prosecutorial impulse. This debate on Ongwen's responsibility also points to the third of my exploratory perpetrator portraits, which is the depiction of perpetrators not as complex moral lives and existences that are lived under situations of extreme violent upheaval, but as consisting of active choices that represent uncompromised agency. And this tendency is exemplified to some extent doctrinally by the orphan status accorded to defenses and international criminal law in general, but also in the practice of international criminal tribunals, where defenses are rarely successful even when alleged. And ICL scholarship too is not immune to this trend, with scholars expressing a certain psychological reservation towards defenses. So if even academics are this wary of lending an inadvertent hand to defendants in finding grounds for excluding punishability, it's perhaps not altogether surprising that those who actually sit in judgment over them have been yet more reluctant. And one example of this is the case of Dražen Erdemović, a young Croat who enlisted in the Bosnian Serb army to feed his growing multi-ethnic family, but then one day found himself dispatched to a farm near the city of Srebrenica, where he was ordered to shoot at several hundred captive Bosnian Muslim men and boys. Erdemović resisted, but he was told that he could either execute these people or he could line up and join them and be shot at himself. Fearing for his life and the lives of his family, Erdemović reluctantly participated in the shooting, and he says he tried to miss as much as possible, so he tried to kill as few people as possible, but by his own account, he ended up killing around 70 Muslim men and boys. The guilt-ridden Erdemović subsequently told the story to a French journalist, whereupon he was promptly arrested and transferred to The Hague, Erdemovich initially pled guilty to the charge of crimes against humanity. This was not the ICTY's favorite case, a guilt-ridden young soldier. Then he appealed his conviction on the ground that he was acting under duress. By a majority of 3 votes to 2, the chamber rejected the defense of duress, based not on what the reasonable person could be expected to do in Erdemovich's circumstances, but with an absolute moral postulate, which is clear and unmistakable for the implementation of international humanitarian law. According to the majority, trained soldiers, whose very training contemplated the possibility of death, could be expected to display much greater fortitude when they were faced with threats to their own well-being, instead of being exempted from criminal responsibility. No less a figure than Antonio Cassese, widely considered one of the architects of international criminal law, and not exactly a moral slouch himself, condemned the majority for setting intractable standards of behavior that require mankind to perform acts of martyrdom. But there are 2 ways to interpret these differences in opinion in Erdemovich, and why the majority failed to be convinced by Cassese's reasoning. The first, as some scholars argue, is to analyze the majority as having created a special category of persons against whose standards Erdemovich's conduct should be judged. The majority was willing to concede that a reasonable person faced with a threat to his life would have behaved as Erdemovich did. But Erdemovich was not an ordinary person. He was a soldier. And so to ask more of Erdemovich was not to demand that he act like a hero, but to emphasize that he deviated from conduct that was expected of a trained fighter. The second way to understand the decision in Erdemovich, which is suggested by scholars such as Rosa Brooks, is to change the temporal time frame for evaluating Erdemovich's actions. But in this case, not by contracting the time frame as an onguin, but by expanding it, so that Erdemovich was judged not for the stark choices he faced in the here and now, but for how he ended up there to begin with. On Cassese's reading, it was happenstance, coincidence, and sheer moral luck that led Erdemovich to the unimaginable precipice of having to shoot at his fellow Bosnian Muslims. For the majority, though, Erdemovich's fate was sealed not due to circumstances out of his control at the time he pointed his gun at innocent men and boys, but by his own choices that led him to be part of the firing squad near Srebrenica in the first place. This view of Erdemovich's crime requires traveling back in time to his repeated failure to take a real stand, to insist on loyalty to any one group or idea. There is some more critical scholarship on the decisions I have discussed, which interprets them as a sign that perhaps penal codes are not the best moral guides for people who have to make difficult choices. But if the perpetrator portraits that I've sketched are anything to go by, one could argue that this is the general takeaway of international criminal trials for accused who faced with the existential loneliness of action in the midst of chronic situations of violent conflict. The puzzle, though, is why would international criminal trials seek to convey this message? After all, historians, political scientists, sociologists, anthropologists, psychologists, pretty much everyone else has ceased to do the same. I want to suggest that the perpetrator microhistories I have just sketched are driven by international criminal law's need to justify itself as a normative project. And this project has to answer 2 fundamental questions. First, why are international criminal courts justified in trying the perpetrators of these violent crimes? And second, even if they are justified in doing so, why is it legitimate to try the specific accused and not the thousands of others who are also complicit in the commission of atrocity? International criminal law attempts to answer these questions by claiming to judge perpetrators in the name of an aspirational political community of humanity. We see this in the rhetoric of international criminal justice institutions that claim to simultaneously represent humanity and in so doing to actually call it into being. As the Rome Statute of the ICC states, the court has jurisdiction over unimaginable atrocities that deeply shock the conscience of humanity. The ad hoc international criminal courts also regularly invoke the imperatives of humanity in their judgments, declaring international crimes to be crimes against all of humankind. The website of the court introducing the ICC is emblazoned with a quote from the former UN Secretary General Kofi Annan declaring, "This cause is the cause of all humanity." ICC judges too have referred to the court as executing the interests of the world community to put people accused of the most heinous crimes against humanity on trial. But as critical scholars point out, all this we talk still leaves open the nature of this presumptive political community that international criminal justice attempts to construct. Who gets included or excluded within this political community? And what do the terms of this inclusion look like? And this is where the figure of the perpetrator assumes a central role. An international criminal trial sets one party, which is the prosecutor, acting on behalf of international society, against the other, which is the defendant. In order for the trial to do so, it needs to construct the perpetrator as a punishable subject, who is sufficiently part of humanity such that he can actually be called to answer to his fellow community members. If that weren't the case, trying him would make as much sense as trying a weevil or a caterpillar who's not capable of either understanding the wrongdoing or the import of any punishment that follows. But the trial simultaneously needs to construct a divide between the defendant who's judged and those who claim to judge him, and who might also be complicit in the wrongdoing. International criminal trials try and square this circle by imagining humanity as a normatively integrated collective that extends normative recognition to everyone, including the offender. But through his actions, the offender is judged to have forfeited his standing as an equal member of the community of humanity. And its members can rightfully call him to account for having broken its normative bonds. At the same time, the narrow focus on the figure of the perpetrator enables the collectivity that constitutes this abstract international community to bracket its own responsibility towards the harm and also those who suffer the harm. It also incentivizes the construction of Manichaean narratives, with wholly innocent victims on the one hand and deviant perpetrators on the other, who must bear the weight not only of the harm they have perpetrated, but of the justificatory authority of international criminal law. But let's suppose international criminal courts could actually legitimately then claim to try the accused in the name of humanity, as I have just described. This still leaves open the question of who exactly they justified in calling to account, and what exactly do they hope to accomplish by this calling to account. Standard justifications for the ostensible goals of international criminal trials, which include retribution and deterrence, expression of community values, history writing, peace and reconciliation, are much debated in practice, and at least some of them, such as deterrence, seem even more implausible if international criminal courts will only ever try a handful of accused from among the thousands of individuals who were complicit in the perpetration of atrocity. Again, some scholars respond to this charge by saying that you're making a category mistake by arguing that the focus on the few is problematic. This would be so if we treated international criminal trials like standard criminal trials. But international criminal trials are something different. They are, of course, criminal trials, but they're also more than that. Indeed, they can be viewed as classic political trials, going beyond the warp and woof of the law to the tensions of our public identity, our myth of history, and our sense of destiny. To say that they're political does not mean that they're partisan. Rather, they're trials, classic political trials, in Ronald Christensen's sense, of presenting Gordian knots in the law. So while a court may cut through the issues with a rule and a sharp decision, the defendant may be convicted or acquitted, the dilemmas of morality, of responsibility, of representation remain. The story and the dilemma continue no matter what the court decides and how it decides. International criminal trials, on this account, might be about avoiding impunity, but they're also about historical truth and national identity, past, present, and future. In this sense, their aims may be both destructive as well as didactic. And what would this mean in practice? International criminal trials are aimed at vanquishing political enemies, both real and perceived, individual and collective. In all cases, though, the enemy is the other, against whom legal process is deployed as a weapon. As I have discussed, trials for mass atrocity often represent the accused as the other, either as someone who's monstrous, or at the very least as representing an idea or a movement or a collective that poses a threat. Paradoxically, prosecuting him is also what makes the threat containable. Historians have argued that mass atrocity trials in the post-war period, for example, were particularly useful as a tool for identifying a small group of intolerable cases to facilitate the rehabilitation of the much larger group of ordinary followers, who could then be reintegrated into the post-war order. On this view, then, handpicking and surgically eliminating the few exceptional perpetrators is not a flaw. It's a virtue of criminal trials for mass atrocity. The perpetrator is tried not only for his own deeds, but also as a proxy for others who may have acted similarly, a representative of a group of malefactors. It is this accused, the other, like Eichmann, the man laden with hideous specific guilt, and the cipher, standing for the whole history of anti-Semitism, who gets filtered and made visible through the international criminal trial. If we accept these explanations for why international criminal trials construct perpetrators in the ways that I've just outlined, the question becomes whether it's possible to achieve these goals of international criminal trials through a different set of narratives. Narratives that don't involve abandoning the project of international criminal justice, but that are more honest. Trial narratives in international criminal law is a battle for the consciousness of judges, of victims, of domestic political constituencies, and an amorphous international community. As I argue, in seeking to justify this normative project, international criminal trials have been complicit in telling perpetrator stories of extraordinary perpetrators who must be prosecuted and punished so that the ordinary business of humanity can continue apace. But what I would like to suggest is that there is another way for the international criminal trial to view the accused. Not, as Susan Sontag said of Eichmann, as one of the great shrieking but unheard creatures from the paintings of Francis Bacon, at whom audiences gape like animals in a zoo, but as moral agents with whom we share a commonality. In other words, international criminal trials can and should address alleged perpetrators of mass atrocities, not as individuals who are granted corrective inclusion through liability into the community of humanity, but as responsible agents who the trial calls to account as equal members of the community of humanity whose values they have breached. This also means that the accused cannot be treated merely, or even primarily, as a stand-in or as a vehicle for communication of moral messages, but he must be treated as a subject in his own right. To treat the defendant not as an outlaw against whom the international community must defend itself is to do justice not only to the victim, who is regularly invoked to legitimate the project of international criminal justice, but also to do justice to the offender by recognizing his status as a member of the political community, who is also bound and protected by the values of this community. As Anthony Duff, the main proponent of this communicative theory of punishment, has argued, by calling upon the defendant to answer for himself, the trial treats the defendant as a civic member. When the defendant plays this role in the trial by explaining himself and his conduct, he in turn recognizing himself as answerable to his fellow community members and thereby their right to judge him. Through this two-way process of communication, the defendant in the trial for mass atrocity is no longer seen as a unit for the attribution of responsibility or the passive object of judgment, but one who must be actively engaged in the process of answering for his conduct. A trial that acknowledges this moral agency of the defendant is part of a retributive justice process still, but it is also capable of symbolically performing the role of reintegration of both victims and perpetrators in the aftermath of violence. It does so through enacting rituals of citizenship, which formally reconcile offenders, victims, and other actors in the trial. Duff is careful to qualify his theory as the ideal account of the criminal trial in transitional justice, rather than a descriptive statement of existing trials for mass atrocity. But as the limited scholarship on accused before International Criminal Tribunal suggests, there is actually more scholarship on even defense counsel compared to accused in international criminal law. There are reasons to be optimistic that international criminal trial processes can beguile defendants into playing the justice game, almost despite themselves. In rare cases, they can even become cathartic sites for expressions of remorse and repentance, as was the case for Doik, the former Khmer Rouge prison commander, whose guilty plea and raw confessional statements in court were motivated partly by the desire that humankind should know and accept him as a person again. Treating the accused not as a vehicle for moral messaging, but as an end in itself, does not mean that international criminal trials will cease to have didactic value, but only that the value they express will ask more of those who claim to sit in judgment, both literally and metaphorically. Mass atrocity trials, I argue, should not draw moral boundaries between perpetrators of mass atrocity and those of us who claim to judge them, so that we can tell ourselves those who commit mass atrocities are nothing like us, and to dismiss the culture that produced them as an aberrant monstrosity. Rather than viewing perpetrators with the critical eye of an anthropologist disembarking upon unknown shores, they should challenge us, their audience, to confront the troubling reality of a perpetrator who's not difference-made flesh, but all too human, with a shared capacity for destruction. This will require a different model of the international criminal trial. The model will have to avoid condensing the narrative of mass atrocity onto spare perpetrator silhouettes reminiscent of the sculptures of Giacometti, evoking, as one critic commented, lone trees in winter that have been denuded of their foliage. Instead, trials will have to find a way to acknowledge the circumstances, personal, social, and political, that have a bearing on perpetrator choice and agency. This form of expressivism will involve revisiting some of the substantive doctrines of international criminal law, such as modes of responsibility, potential defenses, mitigatory factors for the purposes of sentencing. Some scholars, for example, have argued that recognizing the reality of perpetrator and not just victim trauma would impact how international criminal trials think about rehabilitation as an aim of punishment. Beyond doctrine, important actors in the trial process could also be nudged into changing how they choose to depict perpetrators both before and during the trial process. For instance, rather than attempting to fit the perpetrator before them into the category of those most responsible for mass atrocity, regardless of the degree of their participation in the crimes with which they're being charged, prosecutors of international criminal courts could instead bring narrower cases that highlight the expressive value of investigating, charging, and prosecuting certain kinds of crimes. Doing so would convey a different expressive message than a prosecutorial strategy that values the symbolic prosecution of high-level perpetrators as having enhanced pedagogical value. But equally importantly, recasting and retelling perpetrator narratives will require judicial humility. In order to judge the unjudgeable, international criminal judgments will need to open a space for reflection on the moral complexity of what makes a perpetrator. by exploring, in Primo Levi's words, the space which separates the victims from the persecutors, and to do so with a lighter hand, and with a less turbid spirit than has been done. Only a schematic rhetoric can claim that the space between victims and perpetrators is empty. It never is. It is studded with obscene or pathetic figures, whom it is indispensable to know if we want to know the human species. I look forward to exploring the space together with you and to your questions. Thank you.
Thank you, Neha. I mean, I've got 47,000 questions. I'm just going to ask one, and then, because we have very little time before we go over. So as you were opening this issue with your 3 pictures to illustrate the thesis, the first thought that came to me, and I couldn't shake it off, was, couldn't you say exactly what you are saying also in relation to a whole raft of domestic criminal proceedings? And that the issue, it seems to me, is that you're really addressing is not international criminal justice, but the model of criminal justice. I'm thinking of notorious cases in domestic law in many countries in the world where someone who's been involved in a mass atrocity goes through exactly the same process. And the essential difficulty with the criminal justice process and model is that the question that it asks is, did they do it? Not why did they do it? And that goes across the domestic and the international. So I'm wondering why you've chosen, in a sense, to put the international on this pedestal and thrown a few arrows at it, when in fact, really your target is a much broader target.
So I think that that probably betrays what I think about the criminal justice process more broadly. In some ways, you're absolutely right to zoom in on that. I have skepticism about the general way in which we think about criminal justice, especially in the US, which is the system I'm most familiar with, the highly punitive and retaliatory process for judging of any kind at all. I think there is still a qualitative difference, though, in what happens internationally. It's the kind of demonization that happens. You're right, in cases that have a higher valence, such as, for example, mass shootings, the Sandy Hook massacre, for example, in the US, or in the case of terrorism trials, domestic terrorism trials as well. You see the similar kind of demonization, but you very rarely see it in your average property offense, for example. Sometimes there may even be sympathy for, if you were someone poor, for example, there might even be some sympathy for the defendant. And the jury, in a jury system, which the civil law doesn't have, but in the common law system, the jury is brought to play with sympathy for the defendant in a much easier way than if we had a jury, for example, at the international criminal trial level, where it's very, very hard to evoke the same sense of familiarity with the defendant. And so there are certainly cases, I think, in the domestic system where you see similar attempts at demonization, but they are far fewer than you see in international criminal law, where it seems ubiquitous. And similarly, if I can think about, again, the discussion on children, for example, some of the examples I've given are really of children, Ongwen, Sese, at the borderline between a child and an adult. Again, in the domestic justice system, no matter what this child may have done, they would be funneled typically through the juvenile justice system. And the way in which the responsibility would be cashed out, perhaps it would invite the same sort of comparisons with demonic behavior, but it would be much easier in the media and otherwise to garner sympathy for the defendant, or at least a sense of familiarity again. Whereas I think there is in international criminal law, there is a much more concerted effort at the distance and at creating the distance. And perhaps that's because we don't feel complicit, even when we should, in why domestic crime happens. So one could make similar sorts of arguments about a lot of domestic crime, that it's born out of structural conditions of inequality and poverty and lack of opportunity and frustration, etc. But somehow we don't feel as complicit in acknowledging those kinds of defenses as we seem to be at the international criminal level.
Let's open it up. There's a lot of questions. We'll go around the room. We'll start here and then there, and then we'll go.
Oh, sorry. Thank you. Super. So I wondered if there's an argument to be made that a lot of, some of the proposals you make at the end are unfeasible in international level because these institutions, and here I'm speaking generally about international institutions, international courts, are inherently insecure in their existence and legitimacy and authority. And so I think you sort of mentioned it, but you don't, I don't know if you have sort of incorporated it as, is this feasible at all, what you suggest? Do we not need this, you talk about humanity, but you don't talk about the institution and what the institution needs to legitimize its own practice, its existence. I'm Slovenian. I remember during the Yugoslav tribunal, like all of these trials were on the TV, people were watching them. So you're not only speaking as an institution to the people in the room, you're speaking to a whole nation. And so the nation will internalize that. So there's an apologetic picture of, of the creation of the tribunal that you're making through that trial and through the picture that you're making of the perpetrator.
Yeah, no, I think that's a very valuable observation about what is happening at the institutional level, and I agree with you that the trial is doing much more in terms of who it's speaking to, and and how the message is being received as well. There's a great quote after the Eichmann trial by an Israeli poet on how the country goes one way and the trial goes this other way, and they're both happening at the same time. The country is going about its business, and the trial people are going about their business in the trial. But the trial is everywhere. Like it's in the air, it's in the water, it's like the dust on the trees. Like you can't ignore the trial if you're in Israel. And so I think that sort of phenomenon is true of a lot of international criminal trials, and not just Eichmann. Eichmann was not an international trial in any case; it was a domestic trial. So I think that's true, that there is a heightened stakes, and the audience is very different compared to your average domestic trial. My sort of reaction, though, to saying, yes, these tribunals are really insecure and that's why they're doing this, is to say it's not helping them. So, the general trajectory of international criminal law that a lot of scholars like to trace is there was this Grotian moment sometime in the 1990s. Then there was a high point, 1998, Rome Statute gets signed and ratified. Then suddenly there was a whole wave of scholarship, trying to pick apart little doctrinal details, and then a whole wave of critical scholarship saying, this project is biased, and here are all the problems with international criminal law. And now it seems to be perma-crisis. And so there is already a legitimacy crisis, and a serious legitimacy crisis in a field that's actually not that long in terms of the object of concentrated study. So I see Gary there, I think your quip, Gary, in one of your writings was, never have so many people written such great stuff about such little with international criminal law. And so it's true that, there's so much been written, and in such a few decades, it's moved from we all love international criminal law to we think this field is dead. That this, in some ways, the legitimacy crisis has already happened. And so whatever is being rescued by international criminal tribunals here, it's not any sense of current legitimacy, I think. And so the question is, what would give them this legitimacy? But it's not business as usual.
Just over on that side over there, and then we'll go on that side over there. Throw it around.
Right. Thank you. Very, very interesting. I was wondering, during your research, did you find a similar approach with victims, but the other way around, like the victim as someone who had lots of opportunity, the victim as the extremely vulnerable. I mean, those kinds of categories that were missing concerning the perpetrator, did you find them concerning the victims there?
So I think the perfectionism myth on both sides attaches to both the perpetrator and the victim. So, you know, there's again in classic criminology, even beyond international criminal law, there's a lot written about the perfect victim as well. Like, you know, who can stand in for perfect victimhood. And one of the nice parts about critical criminology at the domestic level, but more so even at the international level now, is to acknowledge that there are no perfect perpetrators and no perfect victims on either side. And so scholars like Mamdani say that the problem with especially endemic cycles of violence is that perpetrators and victims can cycle between the two positions as well, like just given cycles of violence. But there is, again, this attempt to create the perfect victim or an abstract victimhood, like Sarah Now and Sarah Kendall have done fabulous work on this, is to put together this category of abstract victimhood where there's no particular victim you point to, but an abstract category that's deliberately with an attempt to not be able to attach specific characteristics to individual victims for, and then you claim to speak in the name of. So I think the same tendency happens on both sides in very different ways. And that's what also makes the depiction more binary on both sides.
Yeah, that was such a subtle and rich presentation.
Use the microphone.
You don't need to, do you really need the microphone? It's such a small room. I always worry when my quips are repeated in public. I'm not even sure if they were intended for public consumption, even though I write them down. So I guess I would put a counter view here, which is a kind of de-demonization view of international criminal tribunals, that what the experience that observers have often had, we can say at least at some sort of anthropological level, is that they go to these trials expecting the monster, and the monster is revealed to be merely human. And that this too might be a success or a failure of international criminal trials. I can't really tell which it is, but the exemplary case is probably Hannah Arendt's visit to Jerusalem, where she goes expecting to find the monster and to offer her report on the monster. But as we know, the book isn't subtitled A Report on Monstrosity. It's a report on the banality of evil. And I mean, Leonard Cohen even had a poem about this. You know, 10 fingers, 10 toes. Oh, you did. Sorry, I wasn't there for your opening line, so I'm merely repeating it. So yeah, so this is the idea that somehow there's a declension almost when one encounters this supreme evil, and that reflects an intuition I've had that, you know, our moral outrage about these events is somehow reduced or moderated or indeed made banal in its encounter with criminal categories and criminal trials.
Just to add to that, what I was thinking is you were having this exchange. The single best book about the Nuremberg trial is by Gustav Gilbert, the psychologist who attended to all of the defendants. What was not public was that the psychologists were reporting to the judges. They were retained by the prosecutors, but they were reporting to the judges. And what comes out of the Gilbert book is just the sheer ordinariness of these folk. And the judges, I think, were well aware of it, that these were basically, you know, ordinary folk. You could have dinner with them, you'd probably have a good evening with most of them. You'd never know that they were on the cusp of doing these kinds of things. And that tends to go in the same direction.
Sorry, did you?
Yes, please, come in.
There's one point, however,
Yeah.
and that's the nature of these international crimes is often collective, administrative, bureaucratic, and they often have huge numbers of people involved.
Yeah.
And this is going back to your first point, the thing between domestic criminal law and international criminal law, is that we haven't worked out a way yet of dealing with the reality of the bureaucratic, administrative collectivities in which which terrible harm has occurred, we still try and track individual responsibility. And the fact is, as Justice Jackson said on the opening day of the Nuremberg trials, these broken men here don't look anything like the monstrosity of the actions and events that have occurred. But we have to focus on these people. So this is a huge problem. The human beings in the trial are not capable of matching the events that have occurred.
Neha, you've got a lot to deal with.
I did. So I'm always interested in what I take Eichmann to represent in some ways, even though I did start with Cohen, so it's my own fault for having adopted that framing at the beginning. It's that Eichmann was, he was unprepossessing in general in terms of his physical appearance. When you look at the sketches, when you look at the videos, all of which are on YouTube, he's wearing glasses, he's staring, he's pinching his nose, he has a cold a lot of times when he's talking, and then he's writing these notes. So it's also centering on Eichmann, the personality, and then just the day after day after day after day of testimony, the way it went on in the Eichmann trial. That doesn't happen that often. At the ICC, the number of times you see the accused taking the stand and testifying for day after day after day after day based on detailed notes from behind a glass box, it just doesn't happen. And so I think there is a categorical difference also in terms of the depictions of the accused and even where they're seated. Like, again, I found this out actually only when I was doing some research for this project, that Eichmann in the glass box actually inaugurated a whole trend of putting defendants in glass boxes. It didn't used to be a thing before the Eichmann trial, that the glass box was elevated as well, so Eichmann's glass box. So it's demarcated spatially in terms of the courtroom, it's elevated, and it's made of glass, signaling all the things that glass can as a material. So, glass is dual. It's transparent, at the same time it can be opaque, so there's transparency of the process. It's one of the most fragile building materials, but it's also highly durable, like bulletproof glass. So it can signal a lot of things. And in some ways that's what the Eichmann glass booth ended up signaling to different audiences. So to some people it ended up signaling the banality, the sheer banality of the man, the Hannah Arendts who went and saw him. It also sparked up this massive debate with the Goldhagens versus the Arendts, on whether this was really banal, whether they were really, Arendt was fooled. Eichmann was so brilliant that he could fool this astute observer into buying into the banality, even though that's not what he was. And so I think in some ways the glass booth to me represents the duality of what people took away, even from that picture of Eichmann, and whether what they were seeing was really banal, or whether he was just so brilliant that he'd managed to convince, Hannah Arendt, the genius, into thinking he was banal. And I think that continues in international criminal law, but in an even more so, given the fact that most defendants now, unlike Eichmann, maybe perhaps because of Eichmann, they don't actually take the stand, and not for very long, even when they do.
And just on the individual and the group, I think this is a really significant point, and I just not revealing any confidences or anything, but just faced with the involvement in a case involving the Rohingya, Gambia, and Myanmar, you understand the context in which what they did in 1945 was basically say, look, we can either label the entire country as criminal, or we can find certain individuals, and the international community has basically gone both routes. And the judges of the International Court of Justice are faced now in the Rohingya case with the challenge of sticking a label on the forehead of Myanmar saying, you will be the first country in history that is treated as genocidal. Is that a socially useful thing to do? And the alternative option is the model that you've been throwing things at. What do we do in those circumstances? Do we just give up? Because it is a real issue.
It is, and I don't think the suggestion is so much to give up. I think the suggestion is to try and do better what the South African TRC did badly, which is to say that at some point, and South African TRC has been criticized for lots of things, rightfully so, but also having a very narrow category of, again, perpetrators versus victims, but it did try here and there in its reports. It did try and say, actually, we can't really, there are lots of little perpetrators within us who the TRC doesn't even have the mandate to do anything about because of the way the mandate is set up. And so even though it had a constrained mandate, it went about that mandate in a very constrained way. There were bits and bobs of text in the TRC reports which allowed you to see the tensions that the TRC itself was feeling as it was judging. And so to some extent, I think the way we expect judgments to be so categorical can itself be part of the problem. That there is no categorical way of ruling on the guilt of a single individual sometimes in these cases. And then it gets cashed out in doctrinal terms, in terms such as mitigation or in terms such as this is the mode of responsibility. But I think a more honest expression in the judgment of the difficulty of simply judging what they were being asked to judge, the way that the TRC tried to do, though not very successfully, I think that itself would be an improvement rather than giving up. It's not going to give you as clean answers as a judgment can yield. But to me, that's a preferable model than having to go this way.
Are we allowed to have got time for? Yep.
Cool.
Me too.
How do you? Great presentation, by the way. Could you argue that one of the ways you could present your argument, or part of it, is how do you demonise the crime whilst humanising the person? And if you look at it in that framework, then one answer to that question is, well, they have the agency to say sorry when they're on the witness stand. Not the witness stand, but on the stand. And that individual choice that they have at that time is a fairly powerful way for them to de-demonise themselves. And one of the problems you could argue with Eichmann, banality and all these other things aside, is that he couldn't really even see what the problem was. Not only was he boring, or he came across as boring, whether that was a device or not, but he looked as though he didn't really get what the real problem was in the first place. And if they were able to say sorry, and of course you can't control that, then that's a natural mechanism for the restorative justice that you were referring to as well.
So there's been some recent interesting writing that does speak to the suggestion you're bringing up, which I think is a fruitful suggestion to explore about what forms of expression the accused has and how to assess their genuineness in a way on the stand. So during the ICTY trials, there was a huge debate, for example, on Plavsic, who entered a guilty plea. Some charges were dropped. She expressed her remorse. The judges accepted the remorse, the expression of remorse on the stand. And then once she was in prison, she retracted a lot of what she'd said on the stand, like after the sentence had been handed down. And she was still granted an early release, notwithstanding her retraction of the expression of remorse. And the publication of books actually publicizing what she actually felt and what she'd been forced to stay on the stands, let's say. I think one of the challenges with doing exactly what you just described is this genuineness question, which is not to say that this is not a route that should be explored, but that's something that the international criminal tribunals have struggled with. How do you assess the quality of the remorse that's expressed? To whom is that remorse expressed? For example, Doik, who I spoke about in the Cambodia case, I happened to be in court the day he was making that statement because I worked in the Cambodia tribunal for a while. And you could see a lot of people crying and taking that statement in. And then there were victims who were even angrier, saying, we don't believe him. He's using this because it's convenient for him right now. Where was all this remorse for all the decades when he wasn't on the stand? And so it's really, really hard to also know to whom should this expression of remorse be directed, and who do we expect to acknowledge it, and what happens if they don't believe in that expression of remorse. But I agree with you that trying to de-demonize the accused, whether through her own actions or through the way that the trial process is set up, is a fruitful path to explore.
Time for one more question, I think.
Hi, I wanted to pick up on the point you made about looking at substantive law and also modes of responsibility and ask, because obviously a lot of these prosecutions are brought not for direct perpetration, but for some sort of theory of joint criminal enterprise. And the standards can be exacting, so the prosecution would... So the question essentially is there space within that doctrine to bring a nuanced case that doesn't fundamentally then make it impossible to argue joint criminal enterprise, where the standards can be exacting and therefore you have an incentive to kind of flatten the picture to be able to, quote unquote, sell the case in that sense and persuade the judges?
So I think different systems differ on where the nuance can come in. So for some people, at least for some scholars, the nuance doesn't need to come in at the level of modes of responsibility. It can come ex ante in charging decisions in the first place, not just on modes of responsibility, but on who you charge, for what do you charge them, et cetera, even before you get into modes. The second is whether modes needs to do all the heavy lifting, or can defenses come in alongside modes, for example. And then the third question always becomes, can it come in at the sentencing level, even if you have a completely unitary model of perpetration, which really flattens, and which a lot of systems have, domestic criminal law systems, the unitary method. And so I think there is definitely truth to what you say, that modes can flatten, and it can be hard to capture nuance. But I also think there is much more that goes on before and after, and modes are not necessarily doing a lot of the heavy lifting in the way in which the trial narrative ultimately gets constructed and framed, and then the verdict that's laid down. And so in the Ongwen case, for example, the question was not what mode of responsibility Ongwen should be charged with. The question was why with its 70 counts, which is the highest number of counts. More so than Joseph Kony, they could not capture him, but it's double the number of counts against Joseph Kony. And so a lot of the flattening, I think, or the lack of nuance happens in other places in the criminal trial, and modes is one other anchor in that chain of things that I think tends to flatten.
I think sadly we've reached the hour, or the hour and 10. I always think that the test for whether you've heard a good lecture or a good conversation is whether it's made you think, and challenge you and challenge ourselves, and you've really done that. I think you've got a sense in the room from the questions, but also from the feeling that is coming out. You've put a lot of questions on the table, and that is a wonderful thing. And you did begin with, of course, anyone in my book who starts with a Leonard Cohen quote is up there on the pantheon of greatness. But it was a wonderful lecture, and it provoked thought and reaction. And so on behalf of everyone, and we're going to go outside and have a drink now, and we can join and ask more questions to Neha Jain. But I just hope you'll join me in thanking Professor Jain for a wonderful, and for flying all the way over, and a difficult journey that you made to get here. Thank you so much.